Notice what happened. The judge refused the plea. Why? Because judges don't just rubber stamp deals. If the victim won't cooperate, justice can't be reduced to shortcuts. This decision highlights a clash: efficiency versus truth. Should the case move on quickly, or should deeper accountability always come first?
Up, folks. This courtroom drama is about to get messy. The state of Texas is bringing the heat, and Adam Henlund is in the hot seat. Family violence cases are always explosive. But what happens when the complainant doesn't want to cooperate? Let's dive in.
23 CR 2675, State of Texas versus Adam Henlund. Can I have parties announced for the record for the state?
Travis Banks, the State of Texas.
Defense.
Angela Blake.
Are you Mr. Henlund?
Yes, ma'am.
Counsel, have you received all the discovery?
Welcome back to court. Today's case isn't just about violence, it's about broken trust, shaky testimony, and a system caught between efficiency and truth. Prosecutors want closure, the defense wants mercy, and the judge demands clarity. Buckle up, this courtroom drama is packed with twists, tough choices, and raw emotion.
And did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Henlund, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, the state moves to proceed on the lesser included assault, bodily injury, family, class A.
Any objection?
No objection.
So the complainant in this case, is this complainant his wife or is this the daughter? Who is this complainant in relation to him?
Girlfriend.
A hammer that changes the entire defense. Self-defense could have been his strongest argument, but he waived it. Why? Maybe fear of trial, maybe strategy, maybe something darker. Was this smart caution or reckless surrender of leverage? Audience, think, would you gamble with prison or settle for guaranteed punishment?
Whoa. Did you catch that? The judge straight up said she's not taking this plea deal. Judges don't have to accept plea bargains. And this one smells fishy. If the victim isn't cooperating, the court has to tread carefully. No easy outs here.
All right. So what I can tell you all, this is not a plea agreement I'm not going to accept. Is the complainant aware of this plea agreement?
Complainant is uncooperative, so we have not communicated it to her since she told us she would.
Bombshell moment, he admits uncertainty about fathering the complainant's child. In one sentence, the case shifts from violence to family chaos, honesty, or cold deflection. Either way, the judge sees instability written all over it. What's worse, admitting uncertainty or pretending to know when truth says otherwise?
Not cooperating for this case.
All right. So is this 111 days supposed to be a judgment satisfied?
Yes, Judge.
All right. So I'm not inclined to give him 111 days judgment satisfied on assaulting.
There are circumstances that he does have a partial defense to the case, Your Honor, but he is not pursuing it. There was the complaining witness did use a hammer on him during this incident.
Mm-hmm.
And so he had injuries as well.
All right. I'll agree to 160 days based upon what.
160 days behind bars, a $500 fine, and permanent restrictions under family violence law. That means weapons rights gone, reputation scarred, record locked forever. A few heated moments created life-changing consequences. Question is, was this sentence fair discipline or too light for charges this serious?
You're telling me, I think that's more appropriate than 111 days. So if y'all want to do that, you can. If not, then it'll be set for trial.
Wait, hold up. The complainant allegedly used a hammer on him? That flips the script big time. Self-defense could have been a partial defense, but the defendant isn't pursuing it. Question is, why not? Maybe he thinks a lighter sentence is safer than risking trial.
But I'm not going to give him a judgment satisfied.
We'll accept that, Your Honor.
All right. Do y'all want to?
I can even.
Right. All right. I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes.
Did you understand?
From punishment to soda talk can expect too, right? But it's not a joke. Judges use small lifestyle advice to spark change. Swap alcohol for Sprite. Trouble might vanish. Strange advice. Serious message. Many crimes start with one drink. Sometimes avoiding jail is as simple as choosing lemonade.
The state is proceeding on the lesser included offense of assault, bodily injury, married cohabitation. That's a Class A misdemeanor. The range of punishment is anywhere from a $4,000 fine and up to 1 year in the Bexar County Jail. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to confront any witnesses the state would call, and the right to remain silent? Did you understand by entering this plea bargain agreement?
New case, new struggle. Javier skipped probation meetings for 3 months. To the system, that's betrayal. Probation is freedom on condition. Break it, you risk prison. Simple, but is it fair? Should small mistakes cancel years of progress, or does the law need firmer boundaries?
You were giving up those rights. And did you intend to give up those rights and enter into a plea in this case?
That's fine.
Counsel voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find the defendant guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Just ask the court follow the plea bargain.
All right. Are you the father of the unborn child?
I don't know.
And there it is, courtroom bombshell. The judge asks if he's the father of the unborn child. And his answer? I don't know yet. Yikes. That relationship.
The defense's move, not deny. They frame Javier as struggling, not rebelling. Treatment over prison, mercy over punishment. But the judge pushes back the probation clock already expired. Law versus humanity. Should the rules bend for recovery or remain rigid? Which matters most, rehabilitation or deadlines?
Clearly has problems bigger than this case. What do you think? Was that honesty or pure deflection?
Oh, well, that relationship is not going well if you don't know. All right. So this is what the court is going to do. The court is going to sentence you to 160 days in the Bexar County Jail, give you credit for any time served. There's a $500 fine, time and money to run concurrent. There's an affirmative finding of family violence. There's to be no contact with Digna, D-I-G-N-A, Maria Narvaez, N-E-V-A-R-E-Z, Romero, outside of court proceedings. So if you're going to court.
The judge isn't fooled. Fear, family pressure, excuses all dismissed. She sees relapse, poor choices, and lost opportunities. This is tough love. Until the defendant accepts responsibility, no program will succeed. Brutal honesty. Yes, but maybe that's what addiction truly demands: accountability before forgiveness.
To prove paternity or some other reason for going to court, then yes. But otherwise, your relationship is over. Do you understand?
Yes, ma'am.
Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? Because there's an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. You're going to have to make better decisions, right? And if you cannot drink responsibly and it causes you to have criminal cases, you should not be drinking. And there's nothing missing by drinking. You know what is a great drink? Sprite. And if you add a touch of lime to it, it's so refreshing. Coca-Cola, add some lemon to it. So
Rare moment of transparency. The judge admits she personally intervened before. She gave him chances, support, treatment. He wasted it. Imagine her frustration investing time, energy, even personal involvement, only to watch him relapse. Courts aren't machines. They're people. But even people run out of patience.
so refreshing. That's what I do. And Cappy's has a great drink that I've tried to duplicate and I can't. It's cranberry juice with lemonade in it. And the lemonade surrounds the cranberry, but it tastes so great. So there are other things, other drinks to enjoy other than alcohol.
I understand that.
All right, sweet tea, sometimes people put too much sugar in it, but oh well. Good luck to you, okay?
Okay, pause. This judge just went from sentencing to recommending Sprite with lime and cranberry lemonade instead of alcohol. Honestly, kinda iconic. Judges sometimes humanize the process like this, but let's be real. Do you think this guy's walking out craving a soda or just stressed about jail time?
Thanks.
You're welcome. 18.
2 men, 2 failures. I chose a plea. 1 squandered probation. Both walked away with damaged futures. Justice isn't simple, it's human, messy, unforgiving. Now your turn. Were these rulings fair or too harsh? Comment below, like, share, and subscribe for more courtroom breakdowns. Justice always has another story.
2018 CR 9274W, State of Texas versus Javier Zepeda. Can I have parties announced for the record for the state?
Travis Banks in the state of Texas.
Defense?
Arnold Ortiz.
And are you Mr. Javier Zepeda III?
Yes, Your Honor.
I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision,
Yes,
and states motion to supplement pending motion to enter adjudication of guilt and revoke community supervision. Did you review those documents with your attorney? Did you understand them?
Yes, ma'am.
Are you the same Javier Zepeda III who was placed on deferred adjudication in 2018 CR 9274W for the offense of assault, family second offense on September 5th, 2018 for a period of 3 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 5 in Bexar County, Texas. The defendant Javier Zepeda III did then and there fail to report to the supervision officer in person for the months of May 2020, June 2020, and July 2020 in violation of condition number 5.
How do you plead to that? True or not true?
True. The state will waive and abandon the other allegations in the motion.
All right, any objections?
No objection.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, ma'am.
Court would find violation of condition number 5 true. Is there an agreement?
Your Honor, there's not exactly an agreement. The state is recommending that the defendant be revoked and sentenced to 5 years, but I believe defense has their own request for the court.
All right, defense, what are you requesting?
My client, his family, his employer, and I are requesting that he be allowed to do inpatient, to be allowed an electronic monitoring device, and to continue on probation. We would not be opposed to extending them as long as it's physically possible. And we have witnesses, we have some testimony we think the court will find relevant.
All right, probation?
Your Honor, this case expired in 2021. So an extension of probation